contracts. Okay, chapter 11. This chapter is going to be about real estate contracts. We're going to talk about real estate contract law, but we're also going to just talk about general contract law. You need to know both. So, in this chapter, we're going to talk about the four essential elements that make a contract valid. We're going to talk about the statute of frauds, which usually requires everything to be in writing. We're also going to identify different types of contracts and issues that affect validity of contracts. We're going to learn those terms: valid, void, voidable, unenforceable contracts. We're going to explain various contracts used in the real estate business as well. So let's start off with, what is a contract? Well, contract's a voluntary agreement between legally competent parties to perform or refrain from performing some legal act that is supported by legal consideration to be valid. For any contract to be valid, there got to be something of value exchanged between the parties. That's what consideration is. It's that compensation, that thing of value that's exchanged between the parties. So on page 195, let's highlight that. A contract can be defined as a voluntary agreement between legally competent parties to perform or refrain from performing some legal act that's supported by legal consideration. That's the compensation, what the parties give or receive from each other in the exchange. Okay, so the four essential elements of a valid contract are competent parties, offer and acceptance, consideration, and legality of the object or purpose. Just alone, I put this in a slide all on its own because just alone on its own, you need to know this. Okay, what are the four essential elements to a valid contract? Sounds like it could be an exam question. So we're going to go over each one of those now. So highlight the title and then write the number 4 in front of it. There are 4 essential elements of a valid contract. And then highlight what those elements are: competent parties, offer and acceptance, consideration. And then we're going to highlight those 3 legal forms of consideration. It could be legal tender, exchange of value, or love and affection. And legality of the object is the 4th essential element of a valid contract. And then down the bottom, we'll highlight that the valid contract can be oral or written. And the parole evidence rule states that written contracts take precedence over oral agreements or promises. Now, on here, you don't need to write this, but on here I put the code in just the regular law that says minor spouses authority to join adult spouse in the transfer of realty. Okay. And that's because in the book here, under competent parties, it says to enter into a binding contract in New Jersey, a person must be at least 18 years old and of sound mind. New Jersey permits a married minor who's at least 17 years of age to contract for the purchase of real property. Can you get married in New Jersey if you're a minor? It used to be you can, with parental consent, get married as young as 16 with parental consent. However, there's been some child rights advocates out there trying to help children from sex trafficking and other things of that nature. They overturned that law in New Jersey and did away with it. You know, they saw the lead that President Trump was taking during his first presidency. He actually, a lot of people aren't aware of this. He actually did some major things against human trafficking and particularly in child sex trafficking, because he saw it was becoming a huge problem. And you know, some some of his detractors, they're against everything that he does, so they made the problem even bigger, just by objecting to everything he does. But if you look at during his second presidency, he's already found and recovered 22,000 missing children that were being sex trafficked. That's kind of an insane number that our government let in a lot of unaccompanied minors into our country that were accompanied by people who just claimed to be relatives and they were not. So that's an interesting thing. But anyway, New Jersey, these advocates, they had nothing to do with him, but they saw that that lead was going on. So a couple of years back, they tried to change the law in New Jersey and were successful in doing so. Even with parental consent, you cannot get married in New Jersey anymore. It used to be you could get married as young as 16, but that's no longer a thing. You know, um, heck, they were seeing, we're having a lot of people coming in through our borders and different cultures. They don't care about what our laws are. Uh, in some of these cultures, it's perfectly fine for a 50-year-old man to marry a 7-year-old, but that's disgusting. You know, not that our laws would allow such a thing, but they did allow it to be even, to be younger than 18, which is when you're considered an adult. And they didn't see that as being right either. You're seeing parents that were selling off their kids and basically by marrying them off. Um, so in New Jersey, there's still a law in the books that says minor spouses have the authority to join adult spouse in the transfer of realty, even though they're not allowed to be married in New Jersey uh, younger than 18 anymore. So that's why the book still talks about it, and that's why the state exam probably still has questions on it. I brought this up to the Real Estate Commission and PSI that makes the exams, and I told them, I was like, listen, how could they possibly do this, if they can't legally get married? Um, so the way the PSI works is if a law is still on the books that the politicians did not remove, well, then it's still going to be a question. Okay. That's the way that they work it. So that's why you'll still probably see this on exams. So on my next slide here, I break down those four essential elements in my own words again. So here I put down that competent parties. What is a competent party? You got to be at least 18 years of age, legal age in New Jersey. If under 18, a contract is voidable and can be voided by the minor because they're not a competent party. Can you enter into a contract with a minor? Can an adult enter into a contract with a minor? Guys?
No.
Sure you can. It's not wise to. Right? Because you can't enforce a contract against a minor if they violate it. However, since you're a competent party and an adult, they can enforce the contract against you. This is why you usually don't see it, because it doesn't make sense to do it. Why enter into a contract so that each party can have some sort of a legal enforcement against the other to make sure that they follow through? But if you're in a contract with a minor, well, you can't force the contract on the minor if they want to get out of it. But the minor can enforce it against an adult because the adult's the competent party, not the minor. That's the whole thing there. Now, for exam purposes and exam purposes only, not in real life, because the laws have changed, like I said, and minors can no longer be married in New Jersey, even with parental consent. But the law still has a statute that says that a married minor can sign contracts even though the law doesn't allow them to be married any longer. Okay. So the law actually says under no circumstances can a minor be considered an adult. So you have to be of sound mind. That means sane, sober adults with no mental disease or defect. But for exam purposes only, a minor under the age of 18 who's married would be considered an adult, and contracts they enter into would be legally binding. So when can a contract with a minor be legally enforced?
When they're married.
When they're married. That's what you should know for exams, even though in real life, minors can't be married. I know, sounds silly, doesn't it? It's because there's still a law in the books that says about them signing contracts. So until politicians remove that law, which I don't see them doing that, then it's not going to change. So this will still be on exams. Now, offer and acceptance is the second essential element of a valid contract. It's also known as mutual assent. When the parties are in agreement on all the terms of the contract, it's said that they've come to a meeting of the minds. That means they're aware of and in agreement on all the terms of the contract. So the parties are aware of and in agreement of all the terms of the contract, which must be clearly stated and understood by the parties. Now, for school exam, that definition slightly differs for the school exam versus the state exam. For school exam, they focus on the money. So it's when the parties are in agreement on price, down payment, and financing method. How you coming up with the rest of the do, re, mi? That's how they have defined the meeting of the minds for the school exam. Okay. Versus for state exam, it's the wider definition. It's just when the parties are aware of and in agreement on all the key points of the contract. Okay. You guys all good? Some of you look confused. You all right? Is it just too early? Is that what it is? Haven't had your coffee yet? Come on. Open it up. Have the coffee. All right, here. I haven't had a sip of mine yet either. Here, let's get started. Oh, the elixir of life. At least in the morning. All right. So the third essential element of a valid contract is something of value that the parties give or receive from each other in the exchange. Oh, I gotta make sure that I got this in here. Hold on a second. I do. Okay, great. So consideration is something of value that the parties give or receive from each other in the exchange. It's the entire purchase price. For any kind of legal agreement to be legally enforceable in a court of law, there had to have been an exchange of something of value between the parties, both parties. Can't just write a contract that benefits one side. It has to be mutually beneficial. All right, so there are three legal forms of consideration. And what are they? Well, legal tender. Legal tender is money or a mortgage loan. So in New Jersey, also, here's a little note for you. Deed cannot be recorded in a public record unless it states the full purchase price. Now, sometimes in the public records, in the tax records, you could see $1 listed. Well, that's because when that happens, there's usually not a transfer of sale, just a correction maybe of the spelling of somebody's name or something along that nature. Maybe they did a refinancing, so there was no purchase, there was no sale. So they could put down $1 as the price there that's listed in the tax record. Otherwise, anytime when there's an actual sale, the full actual sale price needs to be listed. So when it's not, it's because we did not do a sale. All right. Now, exchange is something of value. That's like bartering, goods or services, a trading of goods or services. I'll do this in exchange for that, or I'll give you this in exchange if you do this job for me. Okay. That's a legal form of consideration as well. You're exchanging things of value. somebody doing a little work, that's valuable, right? And love and affection. No, they're not talking about prostitution. When they say love and affection, they're talking about like a gift to a relative. But that should be accompanied by an affidavit that confirms that it is a gift. So you can't just record $1 as the sale price in the public records. It should be accompanied by a letter that explains that it is, in fact, a gift. We call that an affidavit. It's a sworn statement. An affidavit is a sworn statement. So you're making a sworn statement that this is, in fact, a gift. All right, so the three legal forms of consideration: legal tender, exchange of something of value, and love and affection. Now let's focus in on this a little bit. You also have to have the legality of the object or purpose of the contract. That's the fourth essential element of a valid contract. Whatever you're selling cannot involve an illegal purpose or object or substance. So whatever you're selling or doing must be legal. You cannot have a legally enforceable contract to kill somebody, right? Because murder is illegal. You cannot have a legally enforceable contract to sell an illegal drug, an illegal controlled substance like cocaine, right? It's an illegal drug. So it must not be against the law, public policy, in order to be an enforceable contract. Come on, we all seen Cops before, right? The show on TV. You all seen Cops, right? There's a wacky episode. I figure you get a little chuckle in the morning. Okay, let's watch a little bit of this episode of Cops. I thought that this was quite funny, and I looked it up, and I eventually found it. So let's check this out. Unfortunately, I didn't see the whole thing. I like to get a little more of it, where the lady who was flagging down the cop because she said that she just got ripped off. She got robbed by somebody. Okay, so let's pick up there. Now, what can cops do? What do cops do? They enforce the law, right? They don't interpret it, but they enforce it, right? And what are the four essential elements of a valid contract that we just went over?
Offer and
Competent parties,
Competent parties,
offer and acceptance,
offer and acceptance,
consideration,
consideration,
legality of object.
legality of the object or the purpose of that contract. Correct. So let's take a look at cops here, and let's get a little chuckle this morning as we see if this cop can enforce this contract for this lady who flags them down.
What's the deal? What's going on?
Well, the lady owes me $20. I gave her a 20 and she didn't give me nothing.
Why does she owe you $20?
$20 bill. I gave her a $20 bill.
For what?
For anything. I don't care. Whatever it's for, but she can give me my money back if she ain't gonna do nothing with it.
Okay, well, you planning to buy some drugs or something? What kind of drugs are you wanting to buy?
Rock.
Rock.
Yes, I was.
You gave her $20
I
back.
gave her $20. She gave me some plaster.
Now you want your $20 back
Thank you.
because she didn't supply you with crack cocaine.
Well, if she shouldn't give me nothing, no plaster, nothing, she should have said no.
What's going on?
She come around here a while ago. There used to be some people live right over there that used to sell.
Yeah.
We was sitting out here on the porch and some chairs. So she said, "Y'all have anything to buy?" I said, "No, baby, we don't have nothing to sell." So she left one around the corner.
Mm-hmm.
Then she come back 10 minutes later, hollering, "Give me my money back up." No, you ain't bought nothing from here. Don't disrespect my child. This is my child.
Mm-hmm.
I don't sell crack. I'm a
Oh my God. So you get the one whack job. She pulls over the cop trying to get her to enforce the law and get her $20 back because she got beat on trying to buy some crack cocaine. Cops can't enforce that. And then you got this lady over here. The mother's like, don't be disrespecting my child. My child didn't sell you any cocaine. We don't do that. I'm a prostitute. Oh my God. You can't believe this stuff. So, like, you didn't see it on film, right? Who would believe that that actually ever happened? That's crazy. All right. Anyway, so the four essential elements of a valid contract, once again, competent parties, offered acceptance, consideration, and legality of the object or purpose of that contract. And there are three legal forms of consideration. We got legal tender, which is money or a mortgage loan, an exchange of value like bartering, and love and affection, like if you give a gift to your child, a house or something like that, right? So a valid contract can be oral or written. It could be verbal. You could have verbal contracts, just not for real estate. Okay, not for the sale of real estate. Anyway, so you can have verbal contracts. I could sell you my cell phone, right? We could have a verbal agreement for a cell phone or my bicycle or something like that, right? And it's perfectly enforceable in a court of law. So verbal contracts and written contracts are legal. However, the parole evidence rule, if I enter into a verbal contract with you to sell you my cell phone, and then, you say you got witnesses, but we don't have anything in writing. But then someone else steps forward and they say, well, I got a contract in writing to buy the cell phone from Victor. Well, the parole evidence rule will kick out the verbal contract, even if you got a witness that claims they heard it all, because the other person has evidence in writing. It even has the word evidence in there. The parole evidence rule basically says that written contracts take precedence over verbal agreements or promises. That's what the parole evidence rule is. You could add that to your definition list. So a contract can be oral or written, but the one in writing got evidence. That's the parole evidence rule. So written contracts take precedence over verbal agreements or promises. That's it. All right. You ever hear the words amendment and addenda? What does that mean in the contract world? Well, the word amendment has the word mend in it. What does it mean to mend something? It means to fix it, right? So you're making changes to a contract to fix it. The word addenda has the word add in it. So you're adding something onto the contract, like another form or another page. So that's just the easy way to remember amendment and addenda, what they are. So amendment is a change to a contract, and any change voids the contract unless both parties initial or sign next to each and every place where you made a modification. Because once you touch a contract with a pen, you just voided the contract until you get both parties' signatures that they agreed to that change. You can't just be making changes to contracts without the parties to the contract agreeing to it, right? Common sense? Yeah. An addendum is like if we need to add a page to the contract. That's called an addenda or addendum. Anytime something is added to the contract, it must be done before both parties sign it. Otherwise, we're practicing law without a license. So if you want something added to the contract, you need to give it to the attorneys during review and have them add it, unless you added it before the parties signed it, before both parties have signed it. So in the book, page 196, let's highlight amendments and addenda and all that stuff. And my chicken scratch on the side, what does that say? I typed it down here. So you guys can make a little note for yourself, either saying this or in your own words, put it in your own words to write less. Licensees must not make changes or additions to a contract after both parties signed it. That would be practicing law without a license. If only one party signed and there's a change, then you could make modifications and changes and just go back to have that one party sign next to the change. You better get them to sign next to the change. You get in trouble for making changes and modifications to a contract without doing so. So let me know when everybody's got the highlights and notes done, and I can move on. Just say in the affirmative, so I don't got to scan everybody's video cameras here to see if you're putting your thumbs up or not.
Done.
Ready.
Okay. Anybody needs more time, you know what to do. Just shout out, tell me that you need more time. Okay. So, what are the Real Estate Commission rules here pertaining to this? Real estate licensees follow both contract law as well as real estate licensing laws. So, the Real Estate Commission rules state that for us to be entitled to a commission, we have to have some sort of authorization in writing. We need it to be hired by the party, right? We can't just put your property up for sale. I'm sorry?
Yes, I passed your greetings to him.
Oh, I don't think you're talking to me, whoever that is. You may want to mute your thing there. All right. So the real estate broker cannot be paid unless they have some sort of authorization in writing by our client or customer in order to be entitled to earn a commission. You can't just put someone's property up on the market for sale and find them a buyer and be like, now you need to pay me some money. Okay, you need to have an agreement in advance to that. They needed to actually hire you. All right. You know, you may think that's common sense, but common sense ain't too common. There's some people out there that do some stupid crap. And so I guess we need to learn all of these additional things now because there's a lot of stupid people out there that do stupid things. So that authorization needs to be in writing, and it'll be in writing usually with a brokerage service agreement now. A listing agreement, exclusive buyer's agency agreement, designated agency agreement, transaction broker agreement, or a referral agreement. Although those referral agreements, they're not signed with the public, they're signed between the agencies. So it needs to be signed by the consumer. And anytime we sign a contract with the consumer, we must give them a duplicate original. Remember, multiple original copies with original signatures, that's a duplicate original. Anytime a contract is fully executed by both parties. And it applies to the sale or lease contract, no matter who the broker is working for on behalf of the seller, buyer, landlord, or tenant. So the statute of frauds requires something to always be in writing. And the statute of frauds says that when it comes to real estate contracts must always be in writing. Now, leases, if there's no real estate agent involved, because anytime a real estate agent's involved, we always got to put everything in writing, always. But you could have a lease that is verbal if there's no real estate agent involved. However, if it's 3 or more years in length, the law states that it needs to be in writing still. So basically, if you got just a contract between a landlord and a tenant, they could have a verbal contract. It's not advised to, it's not too smart to do that, because how would a landlord ever prove that a tenant violated the terms of the lease if you never got it in writing? What, you guys just had to sit down, a little powwow, what all the rules were, and it was understood, and then it was never put in writing? Good luck enforcing that. It's not a bright idea. However, it is legal. But it's recommended you always get it in writing. So leases, they could be recorded in a public record if they're longer leases. So 2 or more years, they can be recorded and added into the public records. Why do we put anything in the public records? You may be thinking, why do we put a lease in the public records? Why would anybody do that? Well, why would we put anything in the public record? Anybody got an answer for that? To put the world on notice of our interest in the property. That's why. So if somebody's got a long-term lease on a property, it's to put the world on notice that you got a long-term interest in that real estate for whatever reason. Okay. So real estate licensees, we follow, New Jersey statutes, and we follow the administrative code. Title 11, Chapter 5. So they both state that any licensee, we do a contract, doesn't matter what it's for or how long it is, it always got to be in writing. But for exams, we need to know what's in the box over here. Sales contracts has to always be in writing, whether a real estate agent's involved or not. And leases, if no agent's involved, they can be in writing. They should be in writing, but they have to be in writing if the lease is 3 years or more. If it's less than 3 years, it could be a verbal agreement. If it's 2 years or more, it can be recorded in the public records. So let's highlight that right here on page 196. And then it's not just a highlight, you have to add this here too. You got to write this in because that should be in there too. Leases longer than 2 years can be recorded. Let me know when you all got that.
Ready?
Yeah, everybody? Yeah, you guys write quick. Okay, so contracts, they could also be express or implied, unilateral or bilateral, executory or executed, valid, unenforceable, voidable, and void. So now we're going to learn what those terms mean. Let's first do the highlights of them and then write the little notes where I made little notes. And then we'll go on to the next slide and we'll go over each one of those with my definitions, which are a bit clearer than some of these here. So take up them highlights and do the notes and let me know when you got stats. Okay.
Ready?
Okay, everybody good? Okay. So express contracts, they lay out all the terms, expressing them in words, leaving nothing to interpretation. So those words should be in writing. Now, an implied contract is one that's expressed by one's actions rather than their words. So sometimes that could leave things to interpretation and not so clear. Some examples of an implied contract would be a lease that expires, but then the landlord accepts your rental payment, your check, for the next month's rent. By their actions of accepting that rental payment without having a new lease signed, It creates an implied contract that the landlord's okay with you staying there for the next month. So now you're becoming a month-to-month tenant with no written lease. Another example of an implied contract is if a bank accepts a payment from the owner after the foreclosure process begins. Usually banks do not do this, but I guess it could happen. And then that would be interpreted by the courts as there being some sort of an agreement between the parties if one of the parties made a claim that, well, I made a payment to the lender. They said that I could get caught up making a little extra payment here and there whenever I could to get caught up. This is why banks will never accept a payment from you once they started the foreclosure process unless you could pay the full outstanding amount, because it could create that implied contract. So if a court were to hear that from somebody, that they said that kind of an excuse, and they could prove that the bank accepted a payment from them after they started the foreclosure process, the court would toss the foreclosure out of court, because it seems like there was an implied contract created by the lender accepting the payment. This is why if you fall behind on your mortgage payments, lenders will be constantly calling you. You're behind on your mortgage payments. You missed the payment. Was that a mistake? We understand sometimes people make mistakes or they forget things. Things get busy in life. Can you make that payment now? Can you make it today? And they'll be doing those collection calls over and over and over again until they actually start the foreclosure process. Then those calls will cease. And even at that point, if you call the lender to make a payment, they will not accept anything less than the full outstanding amount, because it could create that implied contract. Everybody understand that? The difference between express contract and an implied contract? Okay. Now we're going to go over a unilateral versus a bilateral contract. Uni, that's what unilateral begins with. Uni means one. So it's a one-sided agreement where only one party is required to do something. However, only if the other party acts, but they're not required to. Kind of like a lease with an option to buy, right? If you have an option to buy, you're leasing, but you have an option to buy. Does that mean you have to buy? No, you have an option to. But if you exercise your option to buy, is the landlord required to sell it to you at that pre-agreed upon price that they agreed to earlier? Yes. So that's what I mean by a unilateral contract is one where somebody has an option to do something or not. They don't have to do it, but if they do, then the other party has to act. Okay? So if you decide you want to exercise your option to buy, the landlord has to still carry through with their agreement to sell it to you at the pre-agreed upon price by that pre-agreed upon deadline. So here's the litmus test to determine if you're in a unilateral contract or not. This statement, I will do this if you will do that. Okay. That's a unilateral contract. Now, if you could apply this next statement, I will do this and you will do that, that's a bilateral contract. That's the litmus test for a bilateral contract, where both parties are required to do something from the get-go. So any contract that has an option agreements can only be drawn up by attorneys. We cannot prepare option contracts. Only attorneys can. That would be practicing law without a license, like a lease with an option to buy. Do you guys know what the legalities are to create the option? remember, with any contract, the option agreement itself is a contract separate from the lease. You have a lease and an option to buy. What is the thing of value that's exchanged between the parties when you're writing an option to buy? Is it that the tenant is making a lump sum payment, or are they paying a little extra rent that if they do exercise their option to buy, it'll be applied towards the purchase price? And that's the thing of value that allows them to create this option agreement. But what if they don't go through with the option? What if they don't exercise their option to buy? Do you get the money back, or does it just stay out there because that was the cost of having the option? That's why it needs to be drawn up by attorneys. We don't know this stuff because we're not attorneys, right? So, an executed contract. You ever hear that term before? Have you executed the contract? Have you executed the document? We're not asking if you killed it. We're asking if you signed it. That's what the term executed means. You signed it. So, an executed contract is one that's been signed. A fully executed contract is one that's been signed by all. Could have another meaning, depending how you use it in the sentence. An executed contract can mean a fully executed contract can mean that it's been signed by everybody, or it could mean that all the terms within the contract have been fulfilled and there's nothing left to be done. The contract's been fully performed. Whereas an executory contract, tory, means that it's still in progress. So an executory contract is one that all the terms have not yet been fulfilled by the parties. So, has your client executed the contract? What am I asking?
If they've signed it.
And if they did, so do we have a fully executed contract now? What am I asking?
If both have signed it.
There you go. So now at this point, if both have signed the contract, what's the status of the contract at this point?
Fully executed. No? If both signed it?
A second. The status of the contract. It's been fully executed once both parties have signed the contract. But what is the status of the contract at this point? It's in executory status. You're at the beginning of the stage. We only had everybody sign the contract. Now you need to do what the contract required of you, right?
Oh.
So now we got to do what the contract requires. So the contract is in executory status until you fulfilled all the requirements of the contract, and then it's been fully executed again, right? Nothing left to be done. No other obligations to be carried out. That's what that terminology means. Although I've never heard anybody use the term executory in the business. Maybe two attorneys in a room together and they want to impress each other with their vocabulary that they remember it from college. Maybe they may say that, but I never heard anybody actually use that term. But however, executed and fully executed, you're going to hear those terms all the time. And it usually does not deal with the status of the contract. Usually it has to deal with the signing of it. Okay. So let's do, this is split across 2 pages in this book. Executed contract. Let's see. A contract can be executed or executory. Here, actually, on page 198, let's just highlight this. An executed contract can be a signed contract. A fully executed contract would be one that's signed by all parties. That's probably all you need to know for exams. I don't think they're going to get into executory and executed, fully executed statuses. So page 198, just highlight the highlight. All My phone has been ringing off the hook this morning. I don't know who the heck is calling, but. All right. Well, did everybody get that? Yeah. So now let's go over validity. We'll learn the terms valid, void, voidable, and unenforceable. Anybody know what those terms mean? So, a valid contract is one that has the four essential elements attached to it. And they are competent parties,
Offer and acceptance, consideration, and legality of object.
there you go, the four essential elements. So, if you have a contract that has all those four essential elements, it is valid and fully enforceable in a court of law. So a valid contract contains all essential elements. Now, a void contract is a contradictory term in itself because a void contract isn't a contract at all because it's missing one of the essential elements by definition, right? Or it's already been canceled for some reason. So it's not an enforceable contract. So let's highlight here, voidable contract is one that seems on the surface to be valid, but can be rescinded or disaffirmed by one of the parties. I got several examples on the next slide. Let's just do these highlights for now. And then we'll also highlight a contract entered into a minor is usually voidable. That's usually the example that they give. Okay. So a valid contract, here we go. I got the definition for all four of them here. Kind of simple, straightforward. Valid contract has all the four essential elements of the contract. Voidable contract can be disaffirmed by one of the parties. It may be missing one of the essential elements, like a contract with a minor. They're not a competent party, right? Well, in exams, if they're married, it could be, right? Now, one party's under the influence of drugs or alcohol. Well, they're not really competent either then, are they? Or one party's not of sound mind. They have some sort of mental disease or defect, Alzheimer's, dementia, or insanity, or some other radical element that makes them not of sound mind. Now, I used to put on here, bipolar, but I guess it really depends how bad it is, but you get the point. Or by undue influence, that means that they've been taken advantage of, or by duress, force. They've been forced or intimidated to sign. It's not a good idea to go to hospitals and have people signing contracts when they think they're on their deathbed or because they feel like they're very ill and feel like they're on their deathbed, okay? It's not a good idea for you to go having them signing contracts like that. Those kinds of contracts can be disaffirmed by one of the parties because they were taken advantage of or they were under great duress. Now, an unenforceable contract may seem on the surface to be valid. However, neither party can sue to force performance. One example that the book gives, they give a long story where you get these two guys, they're buddies, right? And they got a little boozed up. And so they're both kind of wasted. And one guy's like, I don't have a jersey. I don't have a jersey. And the other guy's like, really? I'd buy your house. You got a nice house. How much you want to sell it for? And they get them into an agreement on how much they want to sell it and buy it for. And they actually write up a contract when they're all drunk. And neither party was competent because they were both drunk at the time they signed the contract. However, if when they both sober up, if they still want to be in the contract with each other, this is known as being valid between the parties. Neither party can sue the other to force performance because they were both drunk when they signed it. But if they wish to carry out the terms still, it's valid between the parties and they can carry out the contract through its terms. It may be a better idea just when they're sober to have them both sign when they're sober. Then you have a fully enforceable contract. So be careful if you're going to get listing agreements signed, or you have a listing and then a contract comes in and you go to meet the clients at their house to get them to sign it, and they got a barbecue going on and a little bit of drinking's going on, drinking or drugging or whatever they're doing. You may want to say, you know what, enjoy your day. I'll come back tomorrow and you can sign tomorrow. It's not a good idea to get them signing when they've been drinking, especially in a party full of people there as witnesses that say, he signed a contract, he was drunk as hell that day, right? Then you're not going to be able to enforce that later on. Now, contracts can be voided as well. So what's a void contract? Contract, it's a contradictory term, because a void contract isn't a contract at all, because it's missing one of those essential elements, or the contract has been canceled because it's been voided, because it was voidable by one of the parties. Okay? So that's what the valid, voidable, unenforceable, and void contracts are. Okay? Okay, moving on. Undue influence is being taken advantage of. You must use extreme caution when dealing with elderly people, or those that may be under the influence of drugs or alcohol. Be aware of any possible mental disease or defect. Alzheimer's, dementia, insanity, extreme conditions of bipolar, etc. You should use caution. Now, there's no way for us to know what's going on in somebody's noggin, right? You can't look at somebody and tell if the cheese is sliding off their cracker. But the best we could do is try to pay attention to what is going on. Look for keys. See if they put down the wrong date and they're off by like 40 years, right? These are little clues that they may not be of sound mind at the moment, right? That the cheese may be slipping off their proverbial cracker. So Alzheimer's, dementia, etc. It is a real thing. But remember, don't look at old people and automatically assume that their cheese is sliding off their cracker, right? You gotta treat them with respect. Respect your elders, but look out for clues, because these things are not uncommon. And if you get a listing from somebody and they have Alzheimer's or dementia, that's not an enforceable contract. They can get out of it. So I'll give you an example. I went for a listing. I met with this older lady. She had some paperwork from other brokerages because she was interviewing a couple brokers to list her property for sale. So she liked me, and I ended up getting the listing from her. She seemed to be pretty sharp upstairs. She knew the questions to ask. She was a sharp cookie. But I get a call a couple days later from someone that says, yeah, I went to my mom's house and I seen all these real estate paperwork from all these different real estate companies. And then she told me that she listed her property for sale with you. She's like, my mom's not selling her property. My mom, she's got Alzheimer's, or she got dementia, or whatever it was. I forget. So what do I do at this point? Do I cancel the contract? What do I do?
Cancel it?
Okay.
I don't think you have to cancel it, right? Because it's void.
Okay. You're all jumping a little bit you're putting the cart before the horse. Okay. so far, I just got a call from some lady claiming to be the daughter and saying that her mom's got Alzheimer's or dementia. I need some kind of proof of that, right? It can't just be canceling the contract because some random lady called me up making these claims. For all I know, it's another real estate agent trying to get me to cancel the contract so that she could list it. I don't know, you know. So I told her, I was like, okay, if that's the case, then I guess you were appointed her guardian, her legal guardian by the court somehow, right? You should have some sort of a corroborating paperwork to that effect. So sure, come on down to our office and I can get you to sign the cancellation of the listing documents and now we go from there. Otherwise, I got to keep looking out for my client's best interest in marketing their property and showing it until you do that. Okay. So if you could, come down to our office with that corroborating paperwork and sign the cancellation of the listing documents, we'll be good. All right. Now, this one actually was a case that she was her mom's legal guardian but you don't know that just by somebody calling over the phone, right? So she came down though. But I learned a lesson from that one. She was pretty sharp lady, but yet, she was I guess, had the stages of Alzheimer's or dementia. So next time I came across an older guy, he was really shaky. Now, him, compared to that last lady who was sharp as a tack, this guy, he was like, his hands were shaky, like this, that he couldn't control, and his thoughts, he was hunting for his words. So I asked the guy, I was like, is there anybody else that needs to sign contracts with us here today? And he was like, oh, thank you for reminding me. He's like, oh, I forgot. He's like, yeah, my son, but he lives right around the corner. Let me get him on the phone. I'll call him up and he'll come right over. He's like, you know how it is. He's like, when they're younger, you take care of them, and when you get older, they start taking care of you. I was like, I understand. And then the guy came around and met with him and his son, and they signed the listing documents. All right, so I was like, all right, that worked pretty good. Now, you never know with people with Alzheimer's or dementia. They may not remember, but I at least asked the question and it stirred something in him that he remembered. Sometimes you may ask them that question, they'll be like, I don't got any kids, but they do because they forget. So I come across another case. It's another older lady, and she seems pretty sharp too. And I asked her because it worked pretty good for the last guy. So I asked her, I was like, is there anybody else that needs to be signing contracts with us here today? And she goes, what are you trying to say? And I was like, if there's anybody that owns the property or needs to be signing contracts with us here today, I don't know. I'm asking you. And she's like, uh-huh. She caught me. She knew what I was doing, so she was pretty sharp. But yeah, I mean, so treat everybody respectfully. Don't treat everybody like they're going crazy, their cheese is sliding off their cracker, like I like to say, they're you never know what's going on, but respect your elders. But it does work for the way that I said it, is there anybody else that needs to be signing contracts with us here today? That worked pretty good for me. So I still use that. So if you guys, come across a situation, older people, they may, if you get a clue from maybe they're hunting for their words or what have you, I mean, you can really ask this to anybody though. Is there anybody else that needs to be signing contracts with us here today? Is there any other co-owners or anybody who has an interest that needs to be signing this contract? Okay. Ask. You never know. Okay, so you guys have highlighted here what the definition of under duress and undue influence means. Duress is force, undue influence, taken advantage of. Don't use force, threats, or intimidation. Okay, now we'll talk about the performance of a contract, and that dates in contracts are merely guides to follow. And that date are merely. Okay, so that needs to be dates. Performance of contract and the dates are merely guides to follow. Learn about the phrase time is of the essence. That's going to be coming up. And we're going to learn ways to discharge a contract. We're going to learn what default and breach of contract means. And I guess we're going to see statute of limitations yet once again. So, what is a statute of limitations? Statute of limitations is a time limit in which one has a right to assert their legal rights. I mean, we usually know of a statute of limitations when it comes to law enforcement bringing you up on charges for violating the law. They have certain time frames in which they could do that, except if it's for murder, of course. But there's certain time limits and time frames that you could bring somebody up on charges. Of course, unless you got a whole political party of people that want to change the law temporarily just so that they could use lawfare against you, like they did a couple years ago in New York City, right? Yeah, where they expanded the time limit in which one can claim sexual assault to like since forever, not even a time frame. And that's how they were trying to get at Trump with that wackadoo lady who claimed that he assaulted her in a changing room in one of the most busiest stores in New York for the high-end stores. Which, as it's come out, if you guys have not heard from that, she's been on so many shows, and you could see how wacky that lady is. But him saying that she's a wacky lady is why he got that judgment against her for defamation of character. So let me say my opinion is she's a wacky lady. Yeah, the one that claims that rape is sexy. Okay, yeah, who lives out in the woods. She's a special one. Anyway, there's a 6-year. See, that's why I don't understand this. You know, we have laws, and they either apply to everybody or they don't. There's not a temporary suspension to laws, which was why that current event blew my mind. I don't know about you guys, whether you like the guy or not, let's look at the laws and how they should be applied. You know how Lady Justice has a blindfold? That's because they're not supposed to judge people differently. You know, everybody should be, the law should be applicable to everybody on an equal basis. So anyway, the statute of limitations is that deadline in which somebody can assert their legal rights, or law enforcement can come after you and file charges by a certain deadline. So there's a 6-year statute of limitations for contracts, foreclosures, mortgages, and cases of fraud. Ironically, real estate brokers have to keep all original documents for how long?
6 years.
Is that just a coincidence, you figure? Or is there such a thing as coincidence? Yeah. And then there's a 10-year statute of limitations for lawsuits to recover real property in New Jersey. If you want to get it back, you'll need to know this for exams. So let's highlight on page 198 there and 199. Actually, yeah. New Jersey generally allows 6 years during which time parties to a contract can seek court action to enforce their rights. The 6-year period applies to contracts, foreclosures, mortgages, and cases of fraud. Lawsuits to recover real property have a 10-year statute of limitations in New Jersey. So you'll need to know that 6 and 10-year statute of limitations. Cause, well, you know cause why. I don't need to say it, do I? All right, everybody got it? Next up, what does breach of contract or default mean? Well, it means you broke the contractual terms of a contract without having a good legal excuse to do so. And therefore, that could make you legally and financially liable to the other party. So dates and contracts are merely guidelines, and nobody's considered to be in breach of contract if a date is missed to perform some act that's stated in the contract. But sometimes we want to ensure we put things in contracts and we want those dates to mean something, to have teeth. So that leads us to this next term. Time is of the essence. It's a strict deadline that must be met. And if somebody's required to do something by this strict deadline and they do not do it by the deadline, the contract is automatically killed. Nothing else needs to be done or said, no other letters sent out, because that deadline is come and gone and the party didn't do what they were supposed to do. We should leave this term up to attorneys to use. Now, we're probably the ones that are going to ask the attorneys to issue a time of the essence order, but we should leave it up to the attorneys to do that, okay? And this is usually in the case where when we have a listing and a buyer makes an offer on the property, there's a lot of information they put in the contract, what the offer price is, what their down payment is, when they're going to bring up the second deposit by, when they're going to produce the mortgage commitment letter by. All right, that's the one where we usually have an issue. If somebody is having trouble getting their mortgage loan, they may have trouble getting that mortgage commitment letter. A mortgage commitment letter is your lender committing to giving the loan, because they've verified the buyer's finances and risk and everything, and now they're analyzing the property as well and analyzing the appraisal statement, the inspection reports, etc. And then they're going to, through their process known as underwriting, they're going to determine whether they're going to grant that loan or not. And if they figure that the risks are acceptable, because it's risk-based lending after all, then they'll issue a mortgage commitment letter. And then that's the date for the mortgage commitment letter that's in the contract. Then the buyer needs to produce that letter to the seller, showing that they could get the loan that the bank committed to giving it to them. And sometimes they have trouble getting that for whatever reason. And so if you notice, you're the listing agent, you notice you didn't get that commitment letter by the deadline date, it's come and gone, or the guide date that's in the contract, because contract dates and contracts are simply guides, not strict deadlines. You give a call, pick up the phone, give a call to the other real estate agent. Hey, we didn't get the mortgage commitment letter yet from the buyer's lender. Is there a problem, or can you get that to me? Do you have it? And if they don't have it, ask them why. Say, why don't you have it? They having a problem getting a loan or something? Oh, no. The mortgage rep, let me just give them a call. I'll find out what's going on. Okay. You would assume they get back to you right away. A day or two goes by. Yo, what's going on with that mortgage commitment letter? Oh, yeah, I followed up with the mortgage rep. They said that they would work on getting that. Okay, well, can I get it? Yeah, let me follow up with them again. Day or two goes by. Nothing yet? No mortgage commitment letter? Or if they start ignoring my calls, I'm going to be like, what's up? Does it seem like they're trying to push us off a little bit? Maybe. Might be having trouble getting that letter. So at this time, I'll give a call to the seller's attorney and I'll say, I think they're having trouble getting that mortgage commitment letter. I followed up with them 3 times already, and they haven't produced it. I need you to issue a time of the essence order for them to produce that letter. So the attorney will write up a letter and send it off to the other side's attorney. It's a time of the essence order for them to produce the mortgage commitment letter within so many days. And if they don't do that, the contract's automatically going to be killed. And then we can put the property back on the market without worries of being in breach of contract, because it's the other side that was in breach, because they were supposed to do it by the deadline of the time of the essence order. Because this is a strict timeline that must be met. Okay, so that term, add it to your definition list. You need to know what default or breach of contract is. It's when you broke a contract without having a good legal excuse to do so. However, those dates in contracts are merely guidelines. They're not deadlines. But time of the essence is it's a strict deadline that must be met. Otherwise, the contract will automatically be killed. So let's highlight time of the essence. This means the contract must be performed within the time limits specified, and any party who's not performed on time is guilty of breach of contract. Page 199. Okay, everybody got that? Any questions? Good. So, assignment. What is assignment or assumption? When you assign a contract, what are you doing? One of the parties is assigning their contractual obligations to another to take over their responsibility to do whatever the contract required of them. Often, this comes up when somebody is assuming your lease. Now, most of the contracts that we put together basically say that these are not assumable contracts. You cannot take over someone else's lease. You cannot sublease without the landlord's written permission. So if the landlord allows you to sublease to someone else, you're never relieved of your obligation to pay the rent if that person who you're subleasing to doesn't pay you. So basically, I rented my property to you. Now you're subleasing to someone else. You're renting to someone else. If they don't pay the rent or they violate the lease, one of the lease contractual terms in any way, you're the one I signed the contract with, so you're the one that's still going to be held liable. You're never relieved of that obligation, even if you're subleasing to someone else. Got it? You always hold primary responsibility. Now, maybe you would like to sublease, but you don't want to be held liable. Is that possible in some way? Sure. It's called novation. Novation of a contract is substituting a contract with a new one. So now the old contract has no more legal force, but the new one took its place. Does. Or if you don't want to replace the entire contract, you could just replace the people that are named in the contract, and that's called novation of the parties. It relieves the original person named in the contract of their obligations, and the new person's taking it over, and they'll become legally responsible now. That's novation of the parties. So you got novation, which is substituting an existing contract with a new one, or novation of the parties where you're replacing the people named in the contract with someone else. And so the original contract or the original person in the contract has no more legal liability or force, and only the new contract takes over, or the new person named in it does. Any questions there? Everybody got that? Novation you'll always see on exams. Always. See, I told you, a lot of questions, a lot of terms from this chapter and the last in exams. Now, the book's definition is not as good as straightforward as mine here. If you don't like mine, you could write your own. But I'm telling you, the book's definition is not as good. So if you want to snap a picture of this, you may want to do that right now. I'm going to move on to the next slide where you could then highlight the definition in the book of novation, which ain't too good. I'm just telling you right now. You'll see for yourself in a moment. Okay, no, everybody's good? All right. So let's highlight assignment. It refers to the transfer of the rights or duties under contract, unless the contract specifically forbids it. The rights may be assigned to a third party. Then it says in the case of assignment, the assigner maintains secondary liability if the assignee breaches the contract. Contract may be modified by novation. Okay, what is novation? Novation, or the substitution of a new contract for an existing agreement. They word things so backwards here that it doesn't make sense. It's you're replacing an existing contract with a new one. Why do they word it like this? Substitution of a new contract for an existing agreement. It doesn't make sense. Who the hell writes like this? Who talks like this? It's like they back into the phrase. Anyway, the new agreement may be between the same parties, or a new party may be substituted for either. You know what? Let me put in my notes here to change that definition. It sucks. What's that, page 199? Where is my notes? Here we go. All right. It's all right. Just a little crazy. Okie dokie dokie dokie. So, everybody got that? These great definitions here? Or do you think my definition explains novation a little bit clearer? Substituting or replacing an existing contract with a new agreement. Their way of writing that is substitution of a new contract for an existing agreement. The new agreement may be between the same parties, or a new party may be substituted for either. It's like they're giving you brain teasers in order to read the statement that you need to study. All right. So let's talk about the different ways that a contract can be discharged. What is that? A contract can be completely performed with all of its terms carried out, or it may be breached. That means broken if one of the parties defaults. In addition, there's various other methods for which a contract may be discharged, and these include partial performance, substantial performance, impossibility of performance, mutual agreement, or operation of law. Let me just explain them so that you have an understanding of these. I don't think they're going to give you specific questions on needing to know what each one of these mean, but it's important that you know what happens in a contract. So, partial performance means the parties did everything. Oh, well, they didn't do everything. They only partially performed what the contract required of them to do. They only did part of what the contract required them to do. So they didn't complete the contract. They didn't fully execute it. Substantial performance means they did everything that the contract required them to do. They just didn't do it exactly the way the contract required them to do it. Impossibility of performance means that the terms of the contract cannot be legally accomplished for some reason. Maybe they can't get the permit to do a construction, or maybe they change the zoning laws, or They're unable to get a certificate of occupancy due to the condition or some other legal condition cannot be met. Or by mutual agreement, both parties can just agree to cancel and back out, right? That's the way to discharge the contract. Nobody will be in breach in that case. Or by operation of law, like voiding contracts as a result of fraud, a contract with a minor, expiration of a statute of limitations on the contract, contracts being altered without all parties agreeing to those altered terms, signing next to those changes on the contract. Remember, consent for any changes to a contract is required by all parties. So default or breach of contract, once again, is when somebody violates the terms of the contract without having a good legal excuse to do so. They could be held legally and financially liable to the other party, in which case they could try to sue you and force you to carry out the terms of the contract and get a judge to issue an injunction. What is an injunction? It's when a judge orders somebody to do something or to refrain from doing something. We had that back in an earlier chapter, in chapter 4, I think, where we learned that term first on page 73. For some reason, it's usually on exam. They want you to know that an injunction is when a judge orders somebody to do something or refrain from doing something. So now we're going to learn about what happens if a seller defaults, what can the buyer do? And then we're going to learn what if a buyer defaults in the contract, what can the seller do? So let's start off with the seller. If the seller defaults on the terms of the contract, what can the buyer do? Well, the buyer can rescind the contract. They can cancel it and recover their earnest money deposits, that good faith deposit. Or the buyer can sue the seller. The lawsuit is called specific performance, where they're forcing the seller to perform the contract as they agreed to in writing. Forcing the seller to carry out the terms of the contract as agreed. That's called specific performance. You need to know that for your definition list. What do you call the lawsuit where that forces one party to do something that they require, that they agreed to do in the contract? It's called specific performance. That's the lawsuit. Now, here's an example I put in here. A seller can back out, the seller backs out of the contract on the day of closing, right? The last possible minute. They show up to the closing, you think they're ready to sign the contracts, and the buyer's ready to move in. They got all their stuff in a moving truck, ready to move right in, right? And then the seller says, yeah, I don't know. I changed my mind. I don't think I want to sell right now. And the buyer's like, say what? I no longer have an apartment. I got all my stuff in a truck outside. I spent tons of money and time and effort, inspections and appraisals and surveys and title searches and this and that and the other thing. And now you're telling me that you don't want to sell? You got a lot of money tied up in this purchase here. So that buyer is probably going to sue the seller, forcing them to turn over the property and sell them the property as they agreed to, because I don't know, it's not a good excuse, good legal excuse, right, to back out of a contract. So that specific performance suit is to get the judge to issue an injunction, forcing them to turn over the property as they agreed to in the contract. Or lastly, the buyer can sue for compensatory damages. They could sue for compensation, for money, moolah, right? Now, what if the buyer defaults? What can the seller do? We'll learn about that on the next slide. But first, I want to go over this. The term liquidated damages. Let's do the highlight here in the book. Liquidated damages are an amount of money agreed to in advance by the buyer and seller that serves as compensation if one of the parties does not live up to the contract. You know what? My definition is a little bit different. My definition is liquidated damages is not an amount of money. It's an agreement made in advance about how much money will serve as compensation if one of the parties breaches the contract. It's a little bit different. Now, this is usually the buyer that would be the one in breach of contract. So, a liquidated damage agreement basically says that, hey, in the event that the buyer breaches the contract, they have to pay the seller so much money. Now, it does not say where that money is coming from. If it does, for example, say that the money is going to come from the deposit money, well, then the seller cannot collect any money beyond the amount that they put down in the deposit. And liquidated damage agreements can be for amounts of money well beyond the amount that was put down as the deposit. So if you had, for example, a liquidated damage agreement that said that if the buyer defaults, they got to pay the seller $20,000. And then they say that money is going to come from the good faith deposit the buyer put down. And if the amount they put down was only $5,000, well, that's all the seller can get is $5,000, and they can't chase after them for any additional amount. So that's my little statement on that. So just so that you understand, if you get a question on exam and it asks what liquidated damages is, don't go saying it's the good faith deposit. No, somebody could write in the contract that that's where the money's coming from. But liquidated damages is just an agreement on how much money is to serve as compensation if one of the parties defaults to the terms of the contract. Okay. So now let's talk about if the buyer defaults, what can the seller do? Can the seller sue the buyer for liquidated damages? Sure, if they're a moron. Serious. That's my explanation. The buyer's got to be a moron for a seller to successfully be able to sue the buyer for liquidated damages. How do you mean this? Why are you disparaging these people? Well, because they're idiots. Okay. Look, if a liquidated damage agreement was added to a contract, it's not a standard thing in all contracts, despite the book trying to make it sound like it is. The seller can declare the contract forfeited if the contract stated they can, and if it was agreed to that they would be awarded compensation from the buyer as liquidated damages. So where that money comes from is a different story altogether. Now, the seller can rescind the contract as if it were never made. However, this would require them to return all the deposit money to the would-be buyer. Or the seller can sue the buyer for specific performance. However, this would require them to sign the deed over to the buyer and then chase after them for the payment. You see what I mean? Like the buyer would need to be a moron, because for a seller to be able to sue them for specific performance, if you're a buyer and you don't want to buy the property, you change your mind. You don't want to buy the property. Don't accept a deed from the seller. What, you think they're just giving you the ownership? So the seller would render the deed, sign the deed, and give it over to the buyer. And then they'll be like, oh, now you got to pay me. You took ownership, because the transfer of ownership takes place upon delivery and acceptance of the deed. You just took the ownership. You said you didn't want it, but you took the ownership. Now you got to pay me. All right. That's what specific performance is. That's why I mean the buyer would need to be a moron, because a seller cannot force you to take on a 30-year mortgage to purchase their house because you changed your mind. But if you took on the ownership of it you do need to pay them. So then they could force you to take on that 30-year mortgage to pay them. And lastly, the seller can sue for compensation as well to get paid. All right, so those are what the seller and buyer can do if the other party defaults. So in the book, we could do these highlights pertaining to that. Go ahead, highlight them. Oh, I never threw out a morning attendance poll. Let me throw one out now too. Come on, all, answer that attendance poll. Hey, does that attendance poll stay up on your screen until I close it, guys? Or once you vote, it disappears from your screen?
Once you vote.
Okay, good. Well, I got 2 more people that need to answer that attendance poll. They got about 20 seconds. 1 person left. 10 seconds. 9, 8, 7, 6, 5, 4, 3, 2, 1. All right. Plenty of time, over a minute for everybody to sign that attendance poll. Nobody, you got 1 person there that still has not. Is that you, Matt? Did you fill out the attendance poll?
Filled out the attendance poll.
All right, then I don't know who is at this point, but now I gave him a minute and a half, so I'm going to end it. There we go. All right, so you guys have all this stuff highlighted here pertaining to specific performance, liquidated damages, and what the seller and buyer can do. All right. Now the rest of this chapter, or a lot of it, talks about just the contracts and how to fill them out. There's a little recap here too. So New Jersey, the preparation of the documents, okay, we're not writing contracts from scratch. These contracts are already prepared by attorneys and approved by the Real Estate Commission. We just need to fill in the blanks. So don't leave blank lines unless leaving a blank line specifically means something as written in a contract. Commercial and industrial properties, we don't prepare the contracts, remember? That'd be practicing law without a license. Instead, we don't prepare commercial, industrial contracts for sale or lease or option agreements. They need to be prepared by attorneys, but we could kick off the project and get the ball rolling by having them sign a term sheet, a non-legally binding term sheet, or an intent to purchase or lease. Then in the contract, all of our contracts have to state the business relationship on how we're intending on representing our clients and who's representing who in the contract. The Opinion 26 notice needs to be the cover page of any contract prepared by real estate licensees for sale or lease, basically informing the consumer they have a right to hire an attorney. What's the first document we give to anyone we intend to do business with, telling them about the different business relationships?
CIS.
The CIS form, the Consumer Information Statement, correct? So on top of the first page of a sales contract, the sales or lease contract, it says this is a legally binding contract. Now, it says a little more than that, but for exam purposes, that'll probably be the answer you select, because they're not going to put down the full paragraph. They'll just say, this is a legally binding contract. And I'll have a screenshot on one of the next slides that shows you the picture of the top of the first page of a contract. Now, it says this is a legally binding contract that'll become Final, within 3 business days during this period, you could choose to consult an attorney who can review and cancel that contract. Okay. And remember, all contracts prepared by licensees must disclose their agency relationships within them. Here's the top of the first page of a sales contract or lease contract. It would be worded like this. See it? This is a legally binding contract. That's how it is on page 202. And then even below that, it says this is a legally binding contract, again with the whole paragraph there. So how does attorney review work? That 3-day attorney review. You got 3 days to start an attorney review once both parties sign the contract, and you give them what?
CIS.
Once they both sign a contract. Should have given that CIS before that. Once they sign a contract, what do you give them right away?
The attorney review, attorney general memorandum.
A duplicate original of the contract they've signed. Right? So how does the attorney review process work? Well, it starts by study by the attorneys. Both parties must receive a duplicate original of the fully executed contract. Then we start counting of time. You do not count business days or legal holidays or weekends. We start counting of time. We deliver the fully executed contracts to both sides' attorneys. We give them 3 business days to start the attorney review. So counting of time, we count 3 business days. We don't count weekends or legal holidays. The review period can be extended or even temporarily halted by both sides, and if they agree upon it. To begin the attorney review, to make the modifications that are necessary, or to cancel the contract. Otherwise, the contract becomes legally binding as it was written. So nobody can make changes to a contract without the other side's approvals. So there will be a notice of disapproval that gets sent out to the other side. That's the way the attorney review starts. One attorney will draw out a letter and they'll send it to the other that says, we are in receipt of your contract for the purchase of 123 Main Street. However, we disapprove of it in its current format. But if you agree to these following changes, then we could conclude attorney review. Sign here. And then they'll send that off to the other side's attorney. And then they got 3 days to respond. And it can go back and forth like this forever. It's just that each party has 3 days to respond to the last correspondence, right? And if you as a real estate agent are not being included in those correspondence, we don't know what's going on. So make sure that you ask attorneys that during the attorney review period, they include both agents in all correspondence. So it would be good if you sent them a cover letter with the contact information for everybody involved that should be getting it, so that they don't got to hunt around. Otherwise, they ain't going to do it. All right. I've had attorney review done in an hour. I've had it done in 3 months. So it can go on for a while until we finally reach a meeting of the minds again. And what is a meeting of the minds? It's when the parties are in agreement on, understand and in agreement on all the major key points of the contract. And then attorney review is concluded. We got to give that federal lead paint disclosure to the owners of property to fill out when a property is older than 1978. And then after the owner fills out the disclosure form, we need to provide it to potential buyers or renters along with the lead paint addendum and offer them a 10-day period in which they can conduct an inspection for lead paint, or they could turn it down and waive that opportunity to conduct an inspection. All right, so we use contract forms that are approved. We have listing agreements. We have exclusive buyer brokerage agreements, designated agency agreements, transaction broker agreements, dual agency agreements. The sales contract doesn't have an official name. You could call it a sales contract while someone else calls it a purchase contract. Well, someone else calls it a purchase and sale contract, or someone else calls it a binder and deposit receipt, or a contract of purchase and sale, or an earnest money agreement. It don't matter what you call it. There's no official name, okay, for the contract. The contract. How about that? We'll call it the contract. That's what we'll call it. Okay, there's no official name, so don't get all high and mighty if the other person doesn't call it the same thing that you do. Okay, there's no official name for it. We'll have them sign it. You know what it is, right? The contract, of course. Silly. You could call it it. Why not? If we could call people it, or other kinds of pronouns, why not use it on contracts, right? There you go. Yeah. So offer and acceptance. What is offer and acceptance? Well, that's one of the essential elements of a valid contract, right? Somebody has to make an offer, somebody needs to accept it. Well, how does that work in real estate? We're going to see in a moment. But let's just first highlight, a broker lists the owner's real estate for sale at the price and conditions that are set by the owner. Page 216. So here's more stuff to highlight. Then we'll get to my slide where I put all my wording there on one page. So do all these highlights and write these notes. This is telling you where this can be located on page 217, above the center of the page graphic image. This one is below the center of the page graphic image. You would write this up there, delivery, acceptance, and signatures not required but recommended, and do all these highlights. And then there's also a note down here, but not required to for offer to be considered accepted. Okay, so do all those highlights and do all those notes and let me know when you got it. Yes, junk calls, junk calls. Everybody have those notes, or is anybody still writing there?
Still right.
Okay.
I got it.
Let me know when you're done.
You can go ahead. I have a screenshot.
Yep. Okay. Not rushing anybody. Okay, so offer and acceptance. How does that work? Okay, so here's the slide I have for the explanation of this scenario. One of the essential elements of a valid contract is a meeting of the minds. That's where the parties to the contract are aware of and in agreement on all the terms of the contract. And this is done through the process of offer and acceptance. So how does offer and acceptance work? Well, first the seller lists their property for sale at a certain agreed upon price. We did a CMA, we did that whole presentation for the owner to let them know how much their home is worth, and we come to a conclusion of how much we're going to list it for. So we list it at that price, and then a buyer makes an offer at that full listing price, or perhaps another amount. Maybe they lowball it or whatever. They go back and forth. And when offers are made, we need to present it to the other side within 24 hours. Then the seller either accepts the offer, or they reject it, or they make a counter offer. But a counter offer is essentially a rejection of the buyer's offer that came in, with the seller making their own offer back to them. So at this point, the buyer is free to walk away. They don't need to even respond to any further correspondence because their offer was essentially rejected, right? That's what a counter offer is. It's also a rejection. Now, if the seller makes a counter offer back, the buyer can then either accept it, reject it, or they can make another counter offer, or they can just walk away. Now, they can go back and forth like this until one of the parties agrees to the other's final terms, their last terms. And when they do, this is called a meeting of the minds. And the contract is accepted pending attorney review. It's still not a legally binding contract until it goes out of attorney review. Or attorney review did not happen and 3 business days have passed without doing attorney review. Then it just becomes legally binding as it was written. Now, in contract negotiations, when they're going back and forth like this, when is an offer considered accepted? Well, it's simply upon notification, when you notify the other party that it's been accepted. And no, it doesn't need to be in writing. You could get on the phone and be like, hey, your last offer your client made, well, they accepted it. Boom, your offer is legally considered accepted. Now, it's always a good idea to follow up and get it in writing. But for exam purposes only, technically, when in contract negotiations, when is an offer considered accepted? Simply when you've been notified. It could be verbal. All right. So I think they even have an exam question based on that. All right. Page. So earnest money deposits, also known as the good faith deposits. This is the money that the buyer puts down when they're making an offer to accompany their offer. The amount should be sufficient enough to show that the buyer is serious with their intentions to go through with this purchase. However, a offer is still legally considered valid even if it's not accompanied by any money deposit whatsoever. But if it's my listing and you're making an offer and you're not even including a minimum of $1,000 at the good faith deposit, I'm going to whisper in the seller's ear not to accept this offer because they're not really serious. I mean, you're going to need a lot more than $1,000 to purchase this property. You're not going to put down at least $1,000 when making an offer. I mean, how serious are you with your intents to go through with it? Or are you making offers on 5 different properties and seeing which one sticks, and then you'll decide which one you'll go with? Even if you get several of them get accepted, are you going to go through and purchase all of them? No. So you're basically screwing someone over and you're not operating in good faith. That's the whole point of a good faith deposit, to show that you're not making offers on a bunch of different properties and seeing what sticks, and then you're going to walk away from the others, maybe not even respond to them. So the deposit gives evidence of the buyer's intention to carry out the terms of the contract, and this deposit is then given to the broker, and the sales contract typically provides the broker or seller's attorney would hold the deposit until closing. If the offer is not accepted, the earnest money deposits return to the would-be buyer immediately. A credit card may not be used to collect earnest money deposits. The amount of the deposits a matter to be agreed upon by the parties. Generally, the deposit should be sufficient enough to discourage the buyer from defaulting and to compensate the seller for taking their property off the market to accept yours. And to cover any expenses the seller might incur by the buyer's defaults. A purchase offer with no earnest money, however, is still valid. Most contracts taking the property off the market and cover any expenses the seller may incur, the buyer defaults, purchaser. Okay, so that's just continuing there. All right, so this is the liquidated damage agreement. It's not standard in all contracts, though it makes it sound that way here. Earnest money deposits, they need to be deposited in the escrow account within 5 business days into that escrow account. That money cannot be commingled with the broker's money. And the broker certainly cannot take that money out and spend it on their own personal use. That's known as conversion. At any time that somebody gives us $10,000 in cashosis or more, we need to report that to the IRS. Are you going to be taking cash deposits, large cash deposits like that from people? I wouldn't. It's too tempting for you to spend some of that money burning a hole in your pocket. That ain't yours. And if you get robbed, or if any of it turns to be counterfeit, it's all drama. We don't want to deal with that. Okay, so here I got my little write-up on my slide about earnest money deposits, that earnest money deposits are sometimes referred to as good faith deposit. It's the money the buyer puts down when making an offer. It shows the buyer's operating in good faith and plans to complete the transaction. An offer is still valid even if made without any good faith deposit, which is customarily least at minimum $1,000. But the buyer is asking the seller to take their property off the market, so they want to make sure the deposit's large enough to show they're serious with their intentions. And if the seller rejects the offer, that deposit money is immediately returned to that would-be buyer. If the offer is accepted, and the money will be credited towards the buyer's purchase price. If the buyer breaches the contract, the seller could claim the money to keep it. Both parties would have to agree to that, and if they don't, then only a judge can decide who gets the money. And the broker has to keep that money in their escrow account until they transfer it over to a court. If there was a liquidated damage agreement added to the contract, which specifies the earnest money would serve as damages, then they could take it. Buyers must deposit any money given by our clients into an escrow or trust account, used only for keeping clients' money for short periods of time. It must be deposited within 5 business days of acceptance from the time the client gave us the money, not from the time the offer was accepted. Any cash deposits, $10,000 or more, must be reported to the IRS. And the broker, if they have, interest-bearing account, cannot keep any interest on that. We can't make a secret profit on our client's money. And the broker is required to keep escrow records for 6 years, like all other records. The only 2 things they keep for 6 months, and they are
Rejected offers.
And expired.
rejected offers and expired listings. Yep. Okay, so a meeting of the minds is said to take place when the parties are in agreement on all the terms, all the details of the contracts. The school exam focuses on the money, so the definition you need to know for school exam is when they're in agreement on price, down payment, and financing method. Basically, how you coming up with the rest of the cashosis for the payment. And a kickback is giving anything of value to an unlicensed person. Who can you pay? Nobody. Who can you be paid by? Only your broker. So giving money to a friend in exchange for a lead, we know that you violated the law already because you can't pay nobody, regardless of the fact that the friend is not licensed, right? And we can't give rebates to sellers So therefore, giving any money back to a seller is illegal. That's kickback. And only buyers of a primary residence can legally receive rebates. And even in that case, we're not paying them directly. It's a direct reduction from our commission before we ever get paid. Closing gifts to buyers should be limited in value. Don't make large gifts. I say keep it around $25. It could be a little bit more, but don't go crazy with closing gifts. We don't want it to be perceived as giving a kickback. So what are the parts of the contract that are essential that must be in every sales contract? Well, contract has to be in writing. Got to have competent parties. There has to be an agreement to buy and sell. Somebody makes an offer and somebody accepts it. There has to be an adequate description of the property. The consideration, that's the full purchase price, whether it's legal tender, exchange of value, or love and affection, needs to be stated. The grantor's agreement to convey the property. The place and time of closing, which is subject to change. And signatures of the parties with initials on every page so that nobody can just swap out one of the pages because the signature line's only on the last page of the contract. So make sure your clients sign the last page or wherever it's required, but make sure they initial every page of the contract. Otherwise, what's to stop somebody from just printing out a new page and swapping it out? Now, these are the non-essential elements to a valid contract because some of these items may not be applicable to this transaction, like any encumbrances to which the deed may be subject to or deed restrictions. Maybe there are no deed restrictions. Earnest money deposit. Well, maybe they're not making an earnest money deposit. It isn't required by law, technically. Mortgage financing, the buyer plans to obtain. What if they're buying all cash, right? So that's why this is not an essential part of the contract. Possession by the buyer. Well, we state when the buyer is going to take possession of the premises, but that's not essential for it to be in the contract. Although all these things are in our standard contracts, but they don't apply to every situation, as you can see. Prorations and adjustments for the final expenses, that's done by the closing agents, and that is definitely not done in the contract. Destruction of the premises. So we have a statement in our contract that says what happens in the event that while we're under contract to sell this property to the buyer, well, what if there's a fire in the house or something happens? Well, our contracts basically say that there's a stipulation there. It's the owner's responsibility to maintain the property in the same condition that the buyer saw it in when they made the offer. So it's their responsibility to get it fixed too. A provision that if either party defaults, what will happen? You could add in a provision to do the final walkthrough into the contract, but it's not necessary to be added to the contract. Contingencies can be added to contracts, but listen, if you want the best offers when there's a multiple offer situation is the ones that are as contingency free as possible. So I guess it would help knowing what a contingency is then, huh? A contingency is a happening which the contract is dependent upon. And if that contingency is not met, it's a way for somebody to get out of the contract. They often begin with the word subject to. The purchase is subject to this or that or the other thing. Like it's subject to the sale of their current home. If you have a current house you need to sell and you make an offer to purchase another one, what do? How do you purchase another house if you did not get to close on your? Well, you could say this purchase is subject to the sale of my current home, which is currently on the market and may be under contract and anticipated closing date of whatever. Now, what if it's not? Then what do? How do you make an offer on a property? Can most people swing the payments on two houses, the mortgage payments on two properties? How would you handle this issue if the buyer needs to purchase the next property before they close on their existing one. I mean, usually we try to coincide the closings so they happen within 30 days of each other. So you're not making 2 mortgage payments in 1 month. But that may not always be possible. So there's something called a swing loan. Okay, that so that you could swing the payment in the interim. Okay, so there's a type of loan that you could get. It's temporary loan. It's usually interest free, but they're not all interest free. For short-term periods, usually not meant to be more than 6 months to a year maximum. If they are a little bit longer, they're probably going to have higher interest rates on them. Because they're personal loans, so that you could cover the payments on 2 houses. And then you pay that loan off in full when you complete the sale of your existing home. And then signatures of witnesses are not necessary for a contract to be valid. We, the licensees, are usually the witness. We witness the signature because we said sign here, sign here, sign here, right? So we're the witness, right? But if you don't sign as a witness, the contract's still valid. It only requires the buyer and seller or landlord and tenant to sign. All right, so other contingencies that we may find in contracts are FHA and VA loans are required to add special contingency clauses into the contract. This is usually added these days by an additional document called an addenda. So what is the purpose of that special contingency clause that's required for all FHA and VA loans that are added into sales contracts? Well, it says that if the house does not appraise for the purchase price, the buyer can get out of the contract without penalty. We'll need to know that. And I don't know if we already got that. We highlighted that somewhere. I think we may have, but we're going to highlight that in several other places in this book. It could be the purchase is subject to an engineer's report or an escape clause. An escape clause is added to a contract when a buyer says the purchase is subject to the sale of my current home. If the seller agrees to those terms, they could insist on adding an escape clause, also known as a kick-out or knockout clause, that says, okay, we'll agree to those terms. However, you're going to allow us to continue marketing the property for sale. And in the event we get another offer that's acceptable in writing, we're going to come back to you and see if you're ready to remove that as a contingency from the contract. And if you're not, we could cancel the contract with you and not be in breach of contract so that we could accept the other one. Okay, so those are the terms. So who does the escape clause protect?
The seller.
The seller. Then we could have liquidated damage agreements added to contracts or short sales notifications and addendum added to contracts. Short sale is just like what it sounds. You're shortchanging somebody in the sale of the property. It's basically when the owner of a property owes more on the house than it's currently worth. You could sell the property for whatever the current market value is, and we negotiate with the seller's lender to accept that amount. Because look, if they got to foreclose on you and then do the sale and list it with a real estate agent, how much are they going to get anyway? That same amount, right? Or probably less, because as time goes on, property values can be dropping still, you know. Here's another contingency, subject to family members' approval, because they may be helping out with the money for the purchase or the down payment or the closing or just the money to buy the property, right? Now, by far, I see this more in the Indian community, all right? You see extended family members helping out even with the money to purchase a house. By far. Now, anybody can have family members that help out with purchasing. But by far, my experiences are that Indian families do tend to stick together a little bit more when it comes to this and contribute to each other's purchasing of homes or real estate for businesses or anything of that nature too. They tend to stick together pretty good that way. So I would definitely ask people if I have clients that are Indian, but I would ask it to anybody really. Um, does anybody's else decision matter in your purchasing here? Because if it does, let's get them through the house first to get their approval before we write up the contract. Instead of writing a bunch of people's names in the contract that the seller doesn't know, we're saying, hey, these are the buyers, but these additional folks, this contract is dependent upon them giving the approval. The seller's gonna be like, what the hell is this? You know, especially if you got like 3 carloads of people whose names all need to be written down there, you know. I've had this actually happen before. I had this young Indian couple that were getting married and they were buying their first house, and the relatives, even the extended family, were the distant relatives were even contributing money towards the purchase of the house. So I was asking them, I was putting a contract together. I was like, do we need anyone else's approval for you to go through with this purchase? And they're like, oh yeah, well, we got all these people. They're gonna be contributing towards money to purchase the house. I was like, oh, so you're not getting a mortgage loan then? And they're like, no, we're going to be buying cash. I'm like, okay. So whose approval do we need? And they start, spelling out all these long Indian names, and one after another. And, I think when I got around 10 names, I was like, whoa, hold on. Can we get everybody together and set up an appointment and meet at the property, and I could just show everybody the property, get them through there and get their approval? It'll seem like your offer is a lot more solid if we put an offer together that's as contingency free as possible. So let's first get everybody through the property that whose approval you need. And then this way we don't need to put that as a contingency in the contract, because they went through it, they looked at it, and they gave their approval. Okay? Can we do that? So we did that, and we set up a meeting, and I met with 3 carloads of people that I had to run them through the house to give their approval. And there was still 2 more people that needed to get the approval, but they were driving down from Canada to look at the house. So I put those 2 names in the contract, but 2 names are a lot better than 3 carloads of people. It was a lot better to do. So hope you guys are all listening to this, because this is actually a pretty common thing, and it's just it's not on exam, but it's very practical that you're going to come across this without a doubt. Now, contracts could be contingent upon zoning or building permit approvals. That's usually more along the lines when it comes to commercial or maybe mixed use properties. So we don't actually draw up the contracts for this, but you still need to know. Like when a builder buys property because they're going to do a subdivision, right? Usually before they ever close on the purchase of the property, they put an offer in to buy the land. And it's subject to a bunch of different things, subject to the zoning approvals and getting the building permits, obtaining the financing to purchase the property, to close on it. There's a lot of hoops they got to go through. So they put a lot of contingencies. Builders usually put a lot of contingencies in contracts when they got a project that they're trying to get approved. They often spend hundreds of thousands, if not millions of dollars, before they ever even purchase the land, because they need to get all the approvals. They got to do engineering and legal stuff, before they could ever go through with that purchase. And then this way, if they don't get the approvals and aren't able to build, they're not stuck with the land or the loan for the land. All right, so let's write here on page 219 what a contingency is. Let's highlight the FHA and VA loan contingency, because that you will absolutely need to know for exams. And then we'll highlight down here the escape clause, what that is. And I wrote here a little note in the side that an escape clause is also known as a kick-out or knockout clause that protects the seller.
So basically the FHA and the VA loans are contingent upon appraisal. That was what we were noting?
Yes.
Okay.
What is the purpose of the special contingency clause that's required to be added into all contracts when the buyer is using an FHA or VA loan? Says that the buyer can get out of the contract without penalty if the property does not appraise for the purchase price. That's what you need to know for exams. Now, contingency clauses usually begin with the word subject to. You know, the purchase is subject to the house appraising for the purchase price, subject to the approval from the family members that are contributing towards the money to buy the house, subject to the sale of the buyer's current home, or subject to the expiration of the lease of the buyer's current lease, because the landlord may not be willing to let him out of the lease early. Things of that nature. Sometimes you have to put these clauses in there to protect your clients. So in the event that they do break the contract because of these reasons, well, you specified in advance that this is a possibility, and if that happens due to this reason, well, then they won't be in breach of contract and can't be held financially or legally liable to the other party, because you disclosed that already too. I'm just waiting for everybody to get their notes down and highlights. No, somebody's at the door. Sveta. Okay.
Good.
Hey, anybody else still writing? Everybody got the notes? The highlights?
1 second. Yeah.
Let me know when you got it. Excuse me.
Yeah, done.
Okay. So here's my slide with the same stuff on there, just a little bit, and a couple more items, you know. Contingency is a happening which contracts are dependent upon or subject to. If those terms are not met, they could get out of the contract without being in breach. Agents should address and remove contingencies as soon as possible. So, an appraisal, subject to an appraisal for FHA VA loans, this is required by law to be put into contracts when they're using FHA and VA loans for the source of financing. It says that they could get out of the contract without penalty if the property does not appraise for the purchase price, or subject to a home inspection by a New Jersey licensed home inspector, not your cousin Vincent that knows some things about construction because he's been in the business. You know, has to be a New Jersey licensed home inspector giving a report. And here's that link where you could verify their license is still active. Or subject to a mortgage loan, obtaining a mortgage loan, or subject to, obtaining a mortgage loan at a specific interest rate. I mean, you can really get fine-tuned in this contingencies. Subject to the approval by a family member that's helping with the money to buy. Or a purchase is subject to the sale of the buyer's current home or the expiration of their current lease. Or subject to the sale of their current home, the seller could insist on an escape clause, also known as a kick-out or knockout clause, being added to the contract. That would allow them to continue marketing the property, and in the event they get another buyer that makes an acceptable offer in writing, they could go back to that other previous buyer and say, are you ready to remove this as a contingency, the sale of your current home? If not, we're going to cancel the contract with you so we could accept this other one that just came in. And then they would not be in breach of contract. Or subject to getting a permit for the property for a particular use, or for construction, or subject to third-party approval, like a bank approval, if it's a short sale, bankruptcy sale, or estate sale. We already went over liquidated damages agreements, but now here we're at this page, 219. If you didn't highlight it before, make sure you highlight it now.
Got it.
Okay. All right, New Jersey has a plain language requirement that they reduced to a simple little blurb now in the book. It used to take up half of a page of the book. But as you could see, the reason why they reduced it to a little blurb. New Jersey has a plain language requirement because we have words in the English language that may have separate legalese meanings to them if used on contracts. So New Jersey has a plain language requirement that applies to contracts of sale that's basically state you have to use words that are common in the everyday English language. But that does not apply to properties valued over $50,000. Only properties valued under $50,000. Not a whole lot of them around anymore, right? So that's why they reduced it to a little blurb here in the book. All right, you've all seen this one before. If you don't have it in your notes, you should snap a screenshot of this and maybe print it out so that you could study all of your rescission periods. But what does the word rescission mean? It's your right to cancel a contract within a given period of time. And the top one is all the rescission periods for sales contracts. And they deal with new construction. All of them except for the last one, which also deals with the resale of existing properties. That's your 3 days for attorney review. You have that 5-day rescission period for new construction for the discovery of off-site conditions. You have a 7-day right of rescission for large in-state subdivisions with 100 lots or more, or if it's less than 100 lots but not less than 10, and there's common area elements involved, like with condominiums and cooperatives, there's that 7-day right of rescission. And there's a 7-day right of rescission for out-of-state properties marketed to New Jersey residents. Commonly, that could be timeshares, but it could be other properties as well, as long as they're new construction. And then we have the mortgage loan contract right of rescissions. There's a 3-day right of rescission for mortgage loans to refinance property that you already own. That after you sign the contract, you could still back out. However, there is no similar right of rescission for purchase money mortgages. What is a purchase money mortgage? Read it backward. Mortgage money to purchase. Any loan used to buy real estate. That would also include seller financing. Once you sign on that loan documents, well, you're married to that loan. You bought it. There's no clawing back that money after it's been paid out to everybody. So there's no right of rescission for loans to buy real estate. So I guess we could highlight that in the book if you wanted to as well. No right of rescission for the purchase money mortgages for loans used to purchase real estate. However, there's that 3-day cool-off period where you can still cancel a loan for refinancing. And we got the Planned Real Estate Development Full Disclosure Act that applies to newly formed common interest communities in New Jersey, such as condominiums and cooperatives and subdivided land. As long as there's at least 10 units there, you got that 7-day right of rescission. Okay.
Got it.
Anybody still writing or anybody need more time?
I got it.
Okay. Option agreements must be prepared by attorneys. Otherwise, we're practicing law without a license. So, any contract that gives somebody an option to do something must be done by an attorney. Like a lease with an option to buy, as an example. Okay, so just highlight here, option agreements in New Jersey should be prepared by attorneys. Have that arrow down to that. Okay, everybody got that?
In my book, it's a little bit different, but I'll just
Yep.
write.
For the option agreement, yeah, it may be a little bit different, but it's got the same lines there that you could still highlight, right?
Yeah, it's just
Yeah.
written a little bit differently.
Yeah, I know they changed up the wording a little bit. I didn't get a new screenshot to replace it, but it's basically the same crap. So just highlight this.
Okay.
Apologies, can you go back one slide?
This one?
Okay, I did get that one. Okay, I wanted to make sure I didn't miss one. Thank you.
You're welcome. All right, so everybody got this one too, the option agreement? I'll take your silence as a yes. All right, so land contracts. I already gave you a better definition of a land contract, but here, this is good enough. A land contract is known as also known as a contract for deed or an installment sales contract. It's a method of seller financing. And then we'll highlight equitable title. Seller does not execute and deliver a deed until, actually, we didn't have, did we mention land contracts yet? We may not have yet. So let's just do these highlights and then we'll go to my next slide, which is a better definition for it though, without a doubt. Well, let's just get these highlights here. All right, everybody good? Here's my slide for land contracts, which you'll need to know for exams. A land contract should not be confused with a ground lease, which we're going to go over in the next chapter. A land contract is a type of seller financing. It's also known as an installment sales contracts because you're making payments in installments and then you're waiting for the deed. So it's kind of like a lease to own. The owner does not give you the deed to the property until you've paid off the full amount owed or some other agreed upon amount. And then at which time you'll get a loan to cover the, you get the mortgage loan to pay off the other balance. So an owner does not turn over the deed to the buyer until they've paid off that full amount owed. Okay, so this is a type of seller financing. In your typical seller financing, it works like when you get a loan from a bank. You get a loan from a bank to buy the property, the seller gives you the deed right away. Okay, so typical seller financing works that way. But in a land contract, the seller doesn't give you the deed to the property until you paid off the full amount owed. It's a little more beneficial for the seller there too. And could be an arrangement the buyer's willing to enter into because they're having trouble getting a loan. So they may agree to these terms. So the buyer will be essentially renting to own, making payments in installments. So they're more than a renter, but they're less than an owner. So until a buyer pays off the full amount owed, they don't get the ownership. However, they do have a financial interest in the property through the payments they've been making, those periodic payments they've been making, building up equity, called equitable title. We know the word title means ownership. Equity is built-in value. So it's the value, the built-in value you have towards the ownership through those periodic payments you've been making. So even though you don't own the real estate, you do have a financial interest towards the ownership of the real estate. That's what equitable title is. Now, if the buyer fails to continue making the payments at any time, the seller does not need to go through the hassle of foreclosure, the long, drawn-out, and expensive process of foreclosure, because the buyer doesn't own the property. They never handed them the deed. However, it's harder to get them out than a typical renter because they've been making payments towards the purchase. So it's easier to get them out than an owner who defaulted on their mortgage loan, but it's harder to get them out than a typical renter. So it's somewhere in between. So equity, that equitable title, equity is the difference between the market value of a property and what's owed on it. Now, equity can be built in several ways. Usually the time that you purchase a property, your equity is equal to your down payment amount. But as you make periodic payments on the house, so you buy the property, here, you buy a property at this value, right? Right here. You put a down payment when you purchased it. So the equity, your market value is here, and you paid this amount in between. So you have that much equity built in. As you make periodic payments, paying down the debt, you're building more equity. It's built in value. You can also build equity by doing improvements to the house, forcing an increase in the value, building equity. Or by simple fluctuation through the market value, because real estate values, they fluctuate. They go up, they go down. And just simply using it as a hedge on the inflation, the market values, you could build equity through the inflation with the as market values fluctuate. So those are the three typical ways of building equity. Okay, and this explains what a land contract is. It's also known as an installment sales contract. You will get it on exams, so you do need to know it. I think you should also know what equitable title and what equity is. All right. So we're pretty much done with this chapter. I got a couple of slides here just showing you, how to prepare for your contracts when you're writing up a contract for the first time. If your brokerage has their own contract form system, you would use that. But if they're using the standard contracts that most agents use in New Jersey, you could go to njrealtor.com/zipform, or to the domain name that I bought that's easier for me to remember anyway, that I point to that same location. njrforms.com will forward you to the New Jersey Realtors contract form system. Open up a window, print out the tax records, and have that information available either from the MLS or the tax record system. Print the MLS listing from the MLS for the property on another screen, because you're going to need to gather information from there as well to prepare your contracts. You got to gather all the license numbers for all the agents involved and the brokerages that they work for, because that's a requirement to be added onto sales contracts these days. So I have a couple of, once again, domain names that I bought that I pointed to the contract form systems on the Real Estate Commission's website. This is a shortcut instead of that really long domain name with uppercase and lowercase and dashes and underscores that is case sensitive. So instead, it's easier just to remember these: njreclicense.com or njrealestatelicensesearch.com. These are domain names that I bought, and I just pointed them to the New Jersey Real Estate Commission's database, where you could search the status of somebody's license. So you could also search for their license number. You should get that pre-qualification or pre-approval letter, have that ready to send over along with the contract. Or if they're buying cash, have that proof of funds letter from the buyer's bank where they're keeping their money. I don't need to know how much money you have, but I need to know you got enough. And a proof of funds letter is a statement from the bank manager. It's a standard form letter. It shows that you have sufficient funds to cover this purchase up to this certain dollar amount, which is filled in by the bank manager who peeks into your bank account, and they ask, how much money do you need to show? Okay, and they put that on the form, and then they stamp it with a raised seal, and they sign it, and that's your proof of funds letter, verifying that you have sufficient funds to carry out this purchase. And then, of course, if the property was built prior to 1978, you're going to need that lead paint addendum that was first filled out by the owner of the property to now have the buyer fill it out, as well as any seller property condition disclosure report that they may have uploaded into the MLS. Now, if they didn't upload the lead paint addendum and the seller's property condition disclosure, you may want to give a call to the real estate agent to see if they could email or fax it over to you. But they should have uploaded it to the MLS. It makes it a lot easier. And that most MLSs allow you to upload supporting documents like that you're going to need if you're going to put together an offer. Agents don't do that. It just makes it tougher to submit offers. So the buyer and seller's attorney information should be gathered because remember, if the offer that you're submitting is accepted, you got 3 business days to start attorney review. So you should be asking that buyer, do you know who's the attorney that you want to use? You got their contact information? We're going to need that. Or start looking. You got 3 business days. The mortgage commitment letter should be produced within 30 days from the completion of attorney review. Those are business days. If you put it in the contract, make sure it lands on a business day. Closing date is typically 60 calendar days. I mean, you could close sooner, but then you're putting stress on everybody. Everybody needs to be on the ball with everything, you know. Otherwise, it could take people could start missing these dates in contracts, and it's just a pain. So just put in there 60 calendar days. You could close comfortably in 60 days without anybody being in a rush, and you have plenty of time to follow up with people, make sure they did everything they're supposed to, right? Now, if that closing ends up with 60 days, ending up on the beginning of next month, push it forward a couple of days, close out the month. You'll have an easier time if that person's getting a loan from the lender. They like to push through those loans at the end of the month there to finish within that same month time frame. Never leave blank lines on a contract. Just write not applicable or put a line through it and then have your client's initial next to that. Make sure even though it's not required by law, they should include a minimum of $1,000 good faith payment along with their offer. Any mortgage down payment, well, that would be an additional down payment that they need to come up with by a certain date. You would write that down in the contract when they need to come up with that second deposit. So for conventional loans, the buyer typically needs 20% down. It could be more, it could be less. But typically it's 20%, but I've seen conventional loans with requirements of only 3% down, you know, so you got to really look at the mortgage pre-qualification or pre-approval letter that they get from the lender to find out how much money the buyer needs to put down, okay? And then work out with them, when can you get this to me by, so that we can collect that money. Now, if it's an FHA loan, 3.5% is the minimum down payment requirement. So you know that's the absolute minimum the buyer needs to put down. So you need to make sure they got that money. If they don't got that money, how are they going to go through with the purchase? They need a minimum of 3.5% to put down as a down payment when purchasing a property. They're also going to need closing costs too. So they're going to need more than this. Closing costs are typically 2 to 3% of the purchase price. Okay. Now, what do closing costs consist of? Well, mostly it's a building up for the coming year's payment for the homeowner's insurance and the and taxes, if they're included in your mortgage payment. See, if you don't include them in the mortgage payment, the purchase can be cheaper because they don't need all that money right now to pay in advance for the coming year's payments of these things. And if they're getting a VA loan because they're a veteran, only veterans can get VA loans, people who are in the military and veterans. No down payment is required at all because the VA guarantees 25% payment of the loan if the veteran defaults. So loans to veterans are typically 100% financing. Now they could put money down to lower their monthly mortgage payments and all, but the veteran's not required to put any money down. So they're typically 100% financing. And yet you got people, these mortgage reps that are pushing FHA loans even on veterans saying, oh, FHA is a better loan. No, it's not. It's because you're not familiar with the VA loan, or it's too much of a hassle for you. There's too much paperwork, okay? So anytime you get a mortgage rep that pushes FHA loans on veterans, they don't know what the hell they're talking about. They're only familiar, they're a one-trick pony. They only know the FHA loans, All right, concession, important word to understand. When you concede something, what does that mean? It means you're giving it up, right? Like when politicians have a race and there's an election, if the count comes in and there's no possible way with the numbers for me to win, you do have them, sometimes they concede the election. They concede to their other person that they've won so that they don't put the subject to public to all these counts and recounts and other kinds of legal battles, right? Well, the same thing applies to when purchasing a house. A concession is money that the seller may be giving up, may be willing to give up to the buyer to help with repairs or closing costs, okay? Now, the maximum concession allowed by law is depending on the type of loan you're getting. If it's an FHA or VA loan, the maximum concession is 6% not of the purchase price, but the loan amount. And the maximum seller concession allowed for a conventional loan is 3% of the loan amount. And I told you, closing costs are typically 2 to 3% of the purchase price. That's a guesstimated number. Yeah, I know. I make up a lot of words. I don't know if guesstimated is in the dictionary. I doubt it. But, I make up a lot of my own words. You could figure out what it means, right? Guesstimated. I'm using an educated guesstimate. All right. So here's the way you would add. Here's one way you could add. Maybe your broker has their own way of writing it in. How to ask for a seller's concession in a contract. Well, you could write, the buyer's requesting a seller concession up to 3% towards the buyer's closing costs and prepaids. That's prepaid interest on the loan. This is a concession and not a loan. Because I write it this way because if the closing costs only equal 2% of the loan amount, and you ask for 3 and the seller agreed to give 3, well, they'll only give 2%, and that 1% goes back to them as their profit. But if I negotiated, they were willing to pay 3%, I'm going to say up to 3% towards the buyer's closing cost and prepaids. So if it's only 2%, well, then they'll get 2% for the closing cost, and the other 1% will go towards their prepaid interest on their loan, paying down the interest on the loan, maybe lowering their monthly mortgage payment a little bit. Hey, now you're a hero if you can negotiate that. If it's a short sale, you can write something simple in the contract like, this is a short sale. Purchase price and commission subject to third-party approval or bank approval or lender approval, right? Me, on mine, I have like a page-long, it's been a while since I did a short sale, but I had a legal-size piece of paper with all kinds of conditions and disclosures for all kinds of situations I came across, because I did a lot of short sales and I came across a lot of nonsense. So I put up an addendum to the contract. It's a whole additional page of statements that would be added into the contract if it's a short sale. But you could do something as simple as this. This is a short sale, purchase price and commission subject to third-party approval. Now, if it is a short sale, only if the seller or their agent specify that the buyer's responsible for obtaining the CO and fire certificates would you actually write that in the contract. Buyer's responsible for obtaining CO and fire certificates. Because in order to get them, if there's an inspection and work needs to be done, well, then the buyer's responsible for getting the work done. And a lot of municipalities know this and don't want the buyers to do work on a house that they don't own yet. So they'll give you the certificate of occupancy and fire inspection certificates, subject to you doing the work and then calling them back to get it re-inspected or to get re-inspected within like 60 days or 90 days of the closing of the sale. Okay, and if the buyer has a home they need to sell before they can continue with the purchase of this one, they could add a clause in the contract like this: purchase subject to the sale of the buyer's current home, and then you got to put the address, which is currently under contract. Put the status there with the anticipated closing date of whatever it is. Okay. Now there's a form you could use as well. There's actually a form here that you could use. I got a copy of it in a shared Google Drive. It's actually a buyer's home sale contingency clause. And it basically looks like this. Put a bunch of terms in there and dates and such. And then everybody signs it. Or if it's subject to the relatives who are helping with the money for the down payment or the purchase of the money to purchase the property. First of all, like I said, try to get all the relatives through so you don't got to write them in the contract as a contingency. And if there's still people that you need to write in, well, you got to do what you got to do. You got to look out for your client's interests. So you would write something like purchase subject to the buyer's relatives and put their names in there. Viewing the home and approving the purchase. They will be contributing money towards the purchase price. Okay. So you just write it plain English. You don't need to be an attorney to be able to write clauses in contracts. You can write it in as simple as that. Okay. As long as it's straightforward and clear. Don't try to write in like legal mumbo jumbo. And that concludes this chapter. Let's do the key terms to review for chapter 11, and then we'll break for lunch. So, doobie-doobie-doo. There are two key terms to review in chapter 11. Are you ready? We ready to get the show on the road? Well, ready or not, here we go. Contract that's been fulfilled or one that's been signed depending on the contract.
Executed contract.
Yes, it is. 12 is A. Buyer's deposit with the purchase contract. What do we call that deposit? What is it often referred to as?
Earnest money.
Earnest money or a good faith deposit. Correct. 9 is B. A contract with a promise by each party. Both parties are required to do something. What do we call those contracts?
Bilateral.
It is a bilateral contract. 2 is C. A contract set down in so many words, leaving nothing to interpretation.
Express.
It is an express contract, correct. 14 is D. A transfer of interest in a contract to a third party.
Assignment.
Assignment, 1 is E. Those legally qualified to enter into contracts.
Escape clause.
What do you call people? Those who are legally defined to enter into contracts.
Competent parties.
Competent parties. 4 is F. Protection for seller when the buyer has another house they need to sell.
That is the escape clause.
That's the escape, kick out, or knockout clause. Correct. 11 is G. Something of value given in exchange.
Consideration.
Consideration. And what are those three legal forms of consideration? Anybody remember? The three legal forms of consideration? Legal tender, exchange of something of value,
Oh, and
barter,
love.
and love and affection. Right? A lot of value to love and affection, and courts do recognize that, as long as it's accompanied by a letter that says, in fact, it is a gift. So 5 was H, the consideration. A violation of a contract. When you violate a contract, what did you do?
Breach of contract?
You breached it. Yep. But 3 is I. Interest acquired by a buyer with a land contract. What do we call that interest that is acquired by a buyer with a land contract?
Equitable title.
Equitable title. 10 is J. A contract that has not yet been performed.
Executory.
Executory contract. 13 is K. Correct. Offer returned to offeror with changes by offeree.
Counteroffer?
It is a counteroffer. 8 is L. A contract not put into words, but shown by one's actions rather than their words.
Implied?
Implied contract. 15 is M. Certain happening in which a contract is dependent upon.
Contingency?
Yeah, we were just going over a bunch of them. Contingencies. 6 is N. An agreement between two parties to perform some legal act.
Contract?
7 is O, a contract. An agreement under which the buyer pays in installments and they wait for the deed.
Land contract.
Also known as?
Seller financing.
Well, it is a type of seller financing, but I was fishing for an installment sales contract.
Oh.
Because they're making payments in installments and then waiting for the deed. Okay. So that concludes key terms 1. Let's do key terms 2. A return to the status quo. That means returning to the way you started.
Recession.
Rescission.
Rescission, sorry.
Rescission. That's okay. 6 is A. Another name for an option contract.
Unilateral.
A unilateral contract. 12 is B. A law requiring certain contracts to be in writing.
Statute of frauds.
The statute of frauds. 8 is C. A contract that is binding, but one party may disaffirm it.
Avoidable contract.
It is a voidable contract. 15 is D. A sum agreed on to serve as damages in the case of future default. What do we call that sum, that amount of money?
Liquidated damages.
Liquidated damages. 1 is E. The process of reaching a meeting of the minds.
Offer and acceptance.
It is. 3 is F. Substitution of a new contract for an existing one. Or here, let's substituting an existing contract with a new one. How about that? Instead of this backwards wording that they use in the book.
Novation.
Novation. 2 is G. A contract that meets all the legal requirements.
Valid contract?
A valid contract, yes. It has the 4 essential elements, right? It meets all the legal requirements. 13 is H. A time within which one is allowed to assert their legal rights.
Statute of limitations?
That is the statute of limitations. 9 is I. Court action, usually asking the seller be forced to sell. as they agreed to in the contract.
Specific for performance.
Yes, it is. 7 is J, specific performance. Convention that written contracts override spoken promises.
Parole evidence rule.
The parole evidence rule is correct. 5 is K. A contract that does not meet all the legal requirements. Contract that does not meet all the legal requirements.
Void.
It is void. That is correct. 14 is L. Seemingly valid contract, but neither party can sue to force performance.
Unenforceable.
It is. 11 is M, an unenforceable contract. A contract binding one party, the other party is free to act or not. What is this describing?
Option.
An option. 4 is N. A contract clause requiring punctual performance. Otherwise, it's killed.
Time is of the essence.
Time is of the essence. It's very important. 10 is O. All right, and that concludes chapter 11. So